combination of learning the law in both a theoretical and practical manners. I think it's a very good way of learning something or going in depth law which is outside our academic curriculum.
It's a simulation of a court proceeding across a variety of different legal subjects. So it could be related to criminal law, civil law, international law.
By putting forth an argument before a judge and convincing that particular person who is listening to you.
It gives you a thorough knowledge of procedural and substantive aspects of law, and it also instills a sense of teamwork in you, which is very important for the profession of law.
Career started when I had taken part in the freshers pool of the university.
There were seniors who told us the benefits of mooting, and they told us like how it's a very good co-curricular to undertake while in law school life.
Actual ability to solve a legal problem, which is something that our curriculum doesn't ever make us do.
Discussions and constant arguments with your teammates is also very exciting. Both roles of speakers and researcher are important. For example, researcher should have a proper knowledge of law, and he or she should see whether the speakers are going on the right track or not. Plus, speakers should hone their advocacy skills, and they should be able to present their arguments before the judges properly.
I just believe this, and I don't know if a lot of people agree with me, but the researcher can make or break the team, in my opinion. So the speakers already have that job of finding the right way to present the arguments and of being convincing enough that a judge can understand you and accept what you're saying. But a researcher has that added job of not only building argumentation but also going into the finer aspects of the research. There's one experience which happened when I was doing Raj Anand, the intellectual property rights, and we were in the finals of that group, and there was Justice Manmohan, a very renowned judge of the Delhi High Court, and we were the respondents, and the appellants had cited a judgment that is Erickson versus Microfinance. It's a competition law judgment, and he was the judge in that case, and he was also judging us. So he very quickly brought their argument about how the very suit is being taken.
I think the semi-final of my Commonwealth International rounds, when we were going up against Australia, we were actually arguing against the Chief Justice of Trinidad and Tobago, and he actually, for the first time that I've ever seen, actually told the Australian team that English wasn't good enough and that our English was better. So I think that was an interesting experience, because we've always, I think as Indians, our accent has to be slightly modified for foreign judges.
Mantra. So I think basically it's not just about hard work, it's about smart work. There is no success mantra, but I think you have to have good research.
Practice.
After that, be prepared for the prospective question.
You should be confident, and you should not worry too much about results. After all, it's just a learning experience.